Good morning, Counsel.
Good morning, Your Honors. May it please the Court. Hella Saxa on behalf of the Commonwealth. With me is Lauren Bernath-Moore, the motion prosecutor in this case. This Court should reverse the motion judge's allowance of the defendant's motion to suppress. When Officers Morgan and Diaz stood on either side of the car and smelled burned marijuana, they had probable cause to search the car and its occupants. Under Massachusetts...
I'm sorry, is it your position that you can search a car based on a civil violation?
No, it is my position that the smell of marijuana provides probable cause under Commonwealth versus Garden, 451 Mass 43, that Massachusetts marijuana continues to be contraband in Massachusetts. It's a controlled substance that is illegal in any quantity, whether...
No, it's only illegal. It's a violation of law, but that's my question. Garden, of course, was done before the new law, and the inference is that the smell of marijuana gives probable cause to believe that there is some quantity of marijuana, and at that time, any quantity of marijuana was a crime to possess. Now it is only a crime to possess more than 1 ounce of marijuana. So is it your view that I'm trying to figure out whether your view is that inference is enough to say that there is more than 1 ounce of marijuana, or that inference is only enough to say that there's less than 1 ounce of marijuana, which would make it only a civil violation, but you think that's still sufficient to justify the search?
It is my position that the smell of marijuana continues to provide probable cause that marijuana is there.
But marijuana in what amount?
Yeah.
Isn't that the question?
That doesn't matter, because
Why?
under the automobile exception in Massachusetts, the police can search for contraband or evidence of a crime. And marijuana, because it's a controlled substance, it is unlawful in any quantity, continues to be contraband. Therefore, the police can search for it.
Well, but contraband in the criminal sense, don't you have to have probable cause to believe that more than 1 ounce is present?
No, you don't. You just have to have probable cause that marijuana is present. And in Garden, the court...
But what makes you say that it's just probable cause that marijuana in any amount is present? Why do you say that?
Because the quantity, in Garden, the quantity or even the criminal nature was not relevant.
But
the
of
court
course
said
it's
that
relevant.
it's probable cause that marijuana is nearby. And that hasn't changed, whether the substance is now subject to a civil fine or to criminal liability. The officer's perception and their ability to smell that marijuana is there has not changed through the change in the law. They can, just as before, determine that through their training and experience that they smell marijuana, and that's what they did here.
Can I ask you a slightly different question? In this case, plainly, the officers had probable cause to arrest, and I guess did arrest the driver for driving under the influence of marijuana.
They had certainly had probable cause that the driver had smoked marijuana before, and they could reasonably infer that he had operated under the influence.
Okay.
Yes.
So they stop a car. There's a driver and the passenger. They have reason to believe that the operator is driving under the influence of marijuana. They smell marijuana in the car. It appears that he's under the influence of it. I assume that would give them the authority to not only arrest the driver, but perhaps search the car for evidence of the crime, to wit, the marijuana. All right, so if they have a basis to search the car to see if there was marijuana there, which would reinforce which would be evidence of the crime, do they have the authority to ask the passenger to step out of the car while they search the car?
Under the circumstances of this case, where the officers observed that perceived the smell of marijuana on both sides of the car, where they observed the two men sharing a cigar that is known to the officers to be used to mask the smell of marijuana, where the driver, the passenger, was not making eye contact. He was hyperventilating, extremely nervous. That gave them the additional reasonable suspicion to also order him out of the car.
But I guess I'm really looking at a more practical point. If they have the authority now to search the car to determine whether there's evidence of the underlying crime, it would seem to me as a practical matter they could ask the passenger to step out of the car.
Absolutely, they have to.
So they could conduct the search without having to sort of work around the passenger's legs, presumably, and under his rear end to find out if there's any marijuana secreted there. Regardless of whether the passenger appeared to be under the influence, is that correct or not?
They, once the officers have probable cause to search the car, they must order the passenger out. And in Garden, again, the evidence was that the smell emanated from the clothes of the driver, and there the court said that that was sufficient to order everybody out of the car.
But you don't think the passage of the new law in 2008 makes any difference whatsoever? Is that what you're saying?
No,
Nothing?
the law makes no difference whatsoever on the search and seizure aspect of marijuana. That is not what this law was intended to do.
So let me ask you this. Let's assume that I'm a police officer and I have reason to believe that someone has an ounce or less of marijuana in their house. Okay? Can I go get a search warrant for that, to search and seize that marijuana? Saying I have reason to believe, based on my conversations with another occupant in the house, that this person who lives there possesses, a half an ounce of marijuana. I'd like to get a search warrant for that. Is that possible after the law is passed?
That is certainly a scenario very different from this one. If there is probable cause...
The marijuana is still contraband. I mean, it's contraband.
Exactly. Because it is still contraband, it is still subject to forfeiture. Therefore, I submit it would be reasonable to get a search warrant under those circumstances. I assume, say, that for any civil violation for which the possession of anything then would be a civil violation, you can search somebody's home for it, because that too is contraband. Well, if the civil violation would indeed have to be contraband, and
So
there are not many...
So if the possession of anything is a civil violation, you say then that the police then may obtain a search warrant to search one's home or one's car for it.
Well, it would certainly depend on what it is. A lot of the examples because
I'm telling you that it is a civil violation to possess it. What difference does it make what it is beyond that, according to your
if
theory?
it is subject to forfeiture, then
Why does forfeiture make a difference in the balance?
Well, under United States v. Carroll, the U.S. Supreme Court case from 1925, the court used a lot of examples in the realm of things subject to forfeiture because they, for example, breached the revenue laws or were concealed in order to avoid duties payable to the state, and there the court said that these things are subject to forfeiture and can be therefore be...
So you could get a search warrant if you think somebody has brought something in from a foreign country and hasn't paid customs duty? You could get a search warrant for their house?
Well, I think that is today is probably regulated under different...
Well, suppose the Commonwealth had evidence that the defendant, the suspect, had numerous jewelry and other items purchased from as a result of his drug dealing business. Would the Commonwealth, in his house, would the Commonwealth be able to get a search warrant for those items based on the fact that they are forfeitable items?
I don't see why not.
Without any evidence of drug dealing, just some probable cause to think that...
Well, if the items themselves are non-criminal, then I think the burden would be much higher. But if in the
Well,
case of marijuana...
Same here.
Well,
A small
here, the
amount
substance
is
is
non-criminal.
Well, the substance continues to be unlawful in any quantity. And
Unlawful in the, is there a, I mean, it's not criminal, all right, but your view is it's still unlawful within the meaning of that word.
well, in Massachusetts, marijuana is a Class D controlled substance.
All right, so if it's unlawful, at least as I read 276 Section 1, which is the search warrant statute, search warrants can be issued for property, the possession of which is unlawful. So
That's right.
consistent with your view is that the possession remains unlawful, therefore, in fact, a search warrant could issue at least under the statute.
Exactly.
And you don't think there's any constitutional proportionality problems with that?
Not in the context of an automobile search. No,
Okay.
certainly not. And the purpose of the new law was not to affect the police's ability to search for a controlled substance. And the defendant's wish that it would have done that doesn't make it so. The effect of this law is very significant in the aspect of its collateral consequences. Anyone who gets a civil fine for marijuana does not get a criminal record and is not subject to any later consequences.
So since it seems that the intent of the legislature was to remove the possession of this amount of marijuana from the criminal scheme, why should the laws or the common law or whatever the laws are governing criminal cases apply?
Because the statute is explicitly said that it doesn't affect any other laws, if I understand your question correctly. The only thing this law did is change the penalty for possession of a small amount of marijuana, because the citizens and the legislature felt that someone should not be punished 20 years later on when they apply for public housing or a student loan or try to adopt a child, that these people would not have a criminal record and would therefore not be suffering consequences of what is perceived to be a fairly minor violation.
Is there any legislative history that helps us understand what the legislature was thinking about, just in terms of whether there is a way for the police to search based on the smell of marijuana? Anything at all?
Well, there is some history around the passing of the vote in 2008, and one thing the voters were told that this change in the law would affect is that it would create a system of civil penalties, and that it would exclude the information from the state's criminal record system. And that, I think, is in agreement with what I say the consequences of this law are, is that they change the later ramifications that possession of a small amount of marijuana has, but they don't change any of the probable cause scenario. The new law didn't overrule Garden. It didn't affect the police's ability to seize and search for contraband. And
so if we agree with you, then I assume that the lesson would be to the citizens of Massachusetts, if you have even one marijuana cigarette, if there's any odor of marijuana at all, you're subject to be searched.
That's correct.
Your car is subject to be searched.
Absolutely.
Before you finish, I have a question just on a different subject. Is your position that the sharing of marijuana between two people is equivalent of distribution? Is the equivalent of distribution?
Yes, it is. And I would submit that the reading of the statute that the amici urge you to accept would, in fact, make any form of distribution other than sale of marijuana a civil violation up to the trafficking amount, because that's the way that the statute is written. Because it specifies sale, manufacture, and trafficking, and it only speaks about possession of more than an ounce. So I think that reading is absolutely unsupported by the statute.
I'm sorry, what reading do you support? That
The reading that the amicus brief from CPCS is urging the court to accept. The law specifically says that it has no effect on any other laws, and it.
So distribution, not for sale, but just distribution, as in the sharing of a marijuana cigarette, would you say that is still criminal?
Continues to be a crime, just as it was before. The only effect is on what is in Section 34, straight possession of marijuana. It has no effect on any of the other crimes, whether it be possession with intent, distribution, or...
There's no evidence of distribution in this case, is there?
There was certainly reasonable suspicion,
Because not found by the judge, but you say in your brief that the other officers smelled marijuana. We don't know where he smelled it.
Oh, yes, we do. In the transcript, the officer testified that he was standing on the passenger side of the car and was able to perceive the...
Yes, but we don't know where in the car he smelled it. That's my point. I know where he was standing.
Well, since the car is a fairly small entity, and he stood by the passenger side window, I think it's fair to assume that it came directly from that source.
What evidence of sharing do you have?
The police observed they perceived the smell on both sides. They observed the men passing back and forth a cigar known to the officers to be used to mask the smell of marijuana.
So the sharing of a cigar suggests that there was an earlier sharing of a marijuana cigarette?
In the context of this case, yes.
All right, thank
Can
you.
Justice Ireland, can I ask one more question? I apologize. I don't mean to beat a dead horse here, but so if a police officer sees someone in the Boston Common smoking a marijuana cigarette, would they at that point have a basis, presumably, to stop them and write out a civil, whatever it is, ordinance violation or whatever whatever the form is, a ticket, essentially? But would they also then have a basis to search them to see if they had any other marijuana that might be forfeitable?
I believe yes, because under Garden, the court said that the...
We're not talking about automobiles, just people.
No, but in Garden, the court specifically said that the police didn't just have probable cause to order everyone out of the car and search the car, but that the officers could search every single occupant of that car. And I think that extends to an encounter of an individual.
Okay.
Thank you very much.
Thank you, Counsel.
May it please the Court, Scott Michaelman, American Civil Liberties Union, for Defendant Appellee Benjamin Cruz. With me is John Reinstein, ACLU of Massachusetts. The Commonwealth argues that the change in law affected by Question 2, codified at Section 32L of Chapter 94C, makes no difference. Essentially, the Commonwealth's position is nothing at all has changed.
No, it's not their position. There are all kinds of things that have changed. The collateral consequences have changed. How this is dealt with procedurally has changed. The question is whether the possession remains unlawful and what the implications are of that.
I think the question, Justice Cordy, is whether possession remains criminal. And possession does not always remain criminal. Probable cause and reasonable suspicion under this Court's precedents have always been tied to the possibility of criminality, a crime that is about to be committed or is being committed or has been committed. And the Commonwealth cites no authority for the proposition that non-criminal contraband, something that may be a violation to possess but not indicative of criminal activity, can be probable cause or reasonable suspicion for a search. The implications of the Commonwealth's position for this Court's police practices jurisprudence are quite profound. According to the Commonwealth's position, an officer could search an individual after merely citing them in the common, as Justice Cordy mentioned, for a civil violation, the officers of the Commonwealth could see through a window that there was a small baggie of marijuana and get a warrant to search a house.
Can you envision a situation where the police could search based on probable cause where marijuana was involved?
Absolutely, Justice Ireland, or Chief Justice Ireland. I think that inquiry would depend on the facts of the case, and there are many circumstances. If there were, for example, a small quantity of marijuana coupled with scales or other paraphernalia that might suggest there would be more. If there were seeds or other indicia that someone was not merely a personal user, but actually a dealer or someone with a great deal of marijuana.
So you're saying there'd have to actually be evidence of a significant amount of marijuana for the police to proceed as if it were a crime?
That's right. There would have to be probable cause, and courts around the Commonwealth would make their usual probable cause determination based on the facts of the case. Now this has worked just fine for a quarter of a century in the state of Oregon, where the Court of Appeals adopted the position we urged about 25 years ago in the Tallman case, and subsequently in several cases the Court of Appeals has adhered to the principle of Tallman, and yet found in certain cases there was probable cause for a search because of other indicia, the seeds, the paraphernalia, and other indicia that would go to a normal probable cause determination as to whether there was evidence of the crime, that is, the crime of possessing more than 1 ounce of marijuana.
But you say the smell alone would not be sufficient.
That's right, Your Honor, because the smell alone does not go to quantity, and as this court has held, when there is something that could be taken as evidence of a criminal possessory offense, such as a gun or a syringe, but is not necessarily indicative of that offense, the police need independent information. They need more information to suggest it is a crime. They may not presume it is.
Like our decision in Landry, I think.
Like your decision in Landry, exactly, Justice Cowan. The Toole, Couture, and Alvarado also support this point. They would need more.
But Landry, in those cases, I mean, you can actually lawfully possess a hypodermic needle. You can actually lawfully possess a gun. You can't lawfully possess marijuana.
That's true, Your Honor. But the distinction
at any amount.
That's true, Justice Cordy. But the distinction they were drawing in that case did have to do with the criminality. And the point I would make is that before it rises to the level, before a situation rises to the level of probable cause or reasonable suspicion to believe a crime has occurred, there has to be more than smell, because smell is not indicative of a crime. And once again, this court's precedents tie the reasonable suspicion inquiry to the commission of a crime.
And you'd say the same thing then if there were a burnt marijuana cigarette in the ashtray. Your same argument would apply. Is that right?
That's correct. They could cite it, however.
Yes, but that's the end of it. They couldn't search the car.
That's correct. Because
under your theory. And so there would have to be a citing, a viewing of what appeared to the officer to be more than 1 ounce, in other words.
Or other paraphernalia indicative that there would be more than 1 ounce, such as scales or the like, but a single joint.
So if there was an ashtray filled with marijuana cigarettes or with the cigars, would that be enough?
Well, as to the cigars, Your Honor, I think it's important to note that the cigars are not themselves illegal, and I think no one would argue that the cigars always cover up marijuana. Taken together, the presence of cigars and a few joints might suggest no more than that individuals were trying to avoid a civil citation. So they would have to have evidence that there was a significant quantity, 1 ounce or more, a criminal quantity of marijuana. They would need the ordinary amount of probable cause to believe that were true, not merely a reasonable belief that they were entitled to issue a citation. So in this case, they should have issued a citation and allowed the defendants to be on their way.
I apologize. I missed that last part. I was looking at the Smalley case in Oregon, very recent, which really seems to say automobile searches for small amounts of marijuana are fine.
Well, I think the Smalley case is an awfully curious one because it directly contradicts 25 years worth of
Right.
Oregon case law. 7 cases decided in that time, 5 of them involving cars. And Smalley, I think, misreads Tallman in saying that Tallman was just about the search incident to arrest exception.
And are all these cases appeals court cases, none of them the Supreme Court cases?
That's correct. The Supreme Court has not had the opportunity to resolve the conflict between the majority of the Court of Appeals decisions
and the most
adopting
recent.
our rule
And the most recent. This is a
this
2002
outlier
case.
Smalley case.
Can I ask you, maybe I missed the point if you were making it, something I asked the Assistant District Attorney. The driver here is, let's assume there's probable cause to arrest him for driving under the influence of marijuana. The smell of marijuana is coming from the car. Can't they then search the car for evidence of the crime?
Yes, Your Honor, that would be possible, but in this case, that's not what happened. They didn't arrest the driver. They didn't attempt to search.
Well, they don't have to arrest him. They have probable cause to arrest him.
Based on what?
But what I think you're suggesting, Justice Cordy, is because of the possibility that they could have arrested the driver or detained him on suspicion of operating under the influence, and then undertaken a search of the car for more and ordered the defendant out.
Not more, just evidence.
Excuse me.
Evidence of the crime for which they have probable cause.
Of the operating under the influence, that they could have, in theory, reached the same result that happened on the facts. But these are not the facts as they transpired. The Commonwealth concedes that they ordered my client, the passenger in the car, out of the car based solely on the smell of burnt marijuana in the car. That was their reason for doing that. And
But they could have. Well, so you concede they could have ordered him out of the car, so they could have conducted the search of the car in connection with the investigation of the driver.
With the potential for OUI, they could have, and in another case they might.
Do you concede that there was probable cause to arrest a driver for operating under the influence?
Well, in this case, potentially, because he was behind the wheel, but the car wasn't going anywhere, and the officers hadn't observed it, in fact, driving anywhere. So that's probably the reason they didn't undertake to arrest the driver on the grounds of OUI. It was a parked car.
I mean, one might think, if alcohol is involved, you usually have field sobriety tests. I mean, you have a variety of things, none of which happened here.
That's correct, Your Honor. So
I don't think there's much evidence that he had an incapacity that he was operating under the influence.
Right.
The fact that he said he smoked a marijuana cigarette sometime earlier in the day.
And the odor is coming out of the car, which suggests maybe like a minute earlier.
Well, in answer to both Your Honor's questions, the odor was very faint by the officer's own testimony, and the driver only admitted to smoking earlier in the day. The officers did not ascertain exactly when. So instead of undertaking a field sobriety test or other steps suggesting that they were actually investigating the possibility of OUI, they went straight to smell equals reasonable suspicion. Let's order him out. And
Did they arrest him and charge him with operating under the influence of marijuana? I can't remember whether that's in this.
I'm not sure.
I think they charged him with anything.
That's in the record.
He wasn't charged in this case, but I don't know whether they separately charged him.
I don't know the answer to that, Your Honor. But I think Your Honor's point goes to a situation that we simply don't have here. Okay. And one could imagine a narrow ruling covering this case and indicating the limits of probable cause and reasonable suspicion based on smell alone without disturbing the police authority to investigate what is still criminal conduct, which is operating under the influence.
Okay.
In
this case, at the motion to suppress hearing, did the Commonwealth put forward any evidence to suggest that there was probable cause to believe the driver was under the influence, apart from what we've heard?
No, Your Honor. Only that he had admitted to smoking sometime earlier in the day. So that's really not the case we have here.
So the Commonwealth didn't put forward any evidence of field sobriety tests or of his arrest of the driver's arrest for that particular crime.
That's correct, Justice Gantz. Returning to a point that the Commonwealth discussed about the possibility of sharing, equaling distribution, I think it's important to note that the evidence for sharing here is very, very weak. And I think, Justice Gantz, you made this point very well, that if two people are seen to be sharing a cigar, that doesn't prove that they've shared anything else. There was no evidence that my client had consumed any marijuana at all, ever, anywhere in the record.
What is your position? Let's assume there actually was an observation of a single marijuana cigarette in the car being shared among two drivers. Would you say that sharing constitutes a distribution and therefore takes them outside of the civil violation?
Well, there's one court of appeals case that has held that sharing constitutes distribution. I would think that would be to adopt, for this court to adopt that position, I think would be contrary to common sense, and I think it would be contrary to the intent behind this law, which was to take law enforcement and the criminal process out of instances of simple possession. Sometimes people possess, sometimes they share. They're not distributing. They're not drug dealers. They're not blanketing the Commonwealth with drugs. They're simply passing the item around between two people. That's very different than the notion of distribution or trafficking. And so I think to the extent there is one appeals court decision suggesting that result, I think it would be unwise for this court to adopt it in light of question 2, and also in light of common sense, that there's a difference between sharing one item and distributing or trafficking on a broad scale. That simply I don't think passes a common sense test. To get to a point that Justice Cowan raised, why should the criminal standards apply? You asked the attorney for the Commonwealth if the intent of question 2 was to decriminalize. I think that's an excellent question. I think that's really important to note. The point of this law is that the people of the Commonwealth did not feel that possession of small quantities of marijuana was serious enough to remain a criminal offense. They downgraded it, and respecting that intent means everything that goes along with that, including that police officers should not be in the business of ferreting out evidence of small amounts of marijuana, including forfeitable property. I think the points made by the court about forfeitable property are absolutely true. That forfeiture means the ability of the state to take ownership of certain types of material that they've already seized, not to go out and seize new material that they don't already have.
Can I ask you this? Can we go to 276, Section 1, the search warrant section?
Sure.
Is it your view that this simply doesn't apply, even though it says a search warrant can be issued if there is probable cause to believe that articles that are unlawful are present someplace?
Yes, Your Honor.
It doesn't apply.
Well, because the unlawfulness in this court's jurisprudence, in terms of search warrants, refers to criminal conduct, and this court's cases have always referred to criminal conduct. If the opposite were true, Justice Cordy, then we could have search warrants issued for baggies of marijuana, the exact sort of thing that the Alaska Supreme Court rejected.
I take it but they rejected it for very different reasons. I take it the United States Constitution wouldn't prohibit a search warrant for contraband, that is, unlawful substance of this type.
Well, the courts are the few federal courts that have addressed this issue under Fourth Amendment law have split on the issue of whether the Fourth Amendment permits a search based on evidence of what would be merely infractionary conduct in the state in which it's occurred. We've cited, to Your Honor, two cases going opposite ways, the Fareed case out of the Western District of New York and the Perdomo case out of the Eighth Circuit, which we would submit was rather conclusory. Of course, this court has always been more protective of privacy rights under Article 14. And therefore, if I may briefly conclude, Justice Ireland. Therefore, in keeping with this Court's historic commitment to the proportionality principle, with civil versus criminal violations, respecting the line between civil and criminal violations, the order of suppression in this case should be affirmed.
Thank you, Counsel.
Thank you.